Namaste viewers and a very warm welcome to this episode of the Indian Lawyer called Understanding FIRs. I am Sushila Varma, advocate and chief consultant with the firm. We thought of bringing this topic to you because all of us at some point of time in our lives or the other are involved with the police. Many a times it is because we have been named for a criminal offence which we have not committed, and sometimes because we have to file a criminal complaint against offenders who have caused us harm. Now, a short introduction. Under the Indian laws, every Indian citizen has a right to request for police help in case a criminal offence has been committed against him or her as per the law laid down in the current Bharatiya Nagrik Suraksha Sanhita 2023, better known as the BNSS. Now let us understand what is an FIR and how does one make it. An FIR in simple language means the first information report. It is the very beginning of setting the criminal justice machinery in motion by allowing the police to investigate into an alleged crime. An FIR must be in writing. If the person cannot write, he must give the information orally and ask the police to put it in writing. All complaints must be signed by the complainant. In case of cognizable offence, information about the cognizable offences can also be given to the police orally or through electronic modes. Now, in case of a non-cognizable offence, the police has to take the permission of a judicial magistrate before making any arrest. The next question that would obviously pop in your minds is, what are cognizable and non-cognizable offences? Putting it simply, cognizable offences are serious criminal offences that can be registered and investigated into by the police without a warrant. These offences are typically grave in nature, involving crimes such as murder, rape, kidnapping, robbery, etc. Non-cognizable offences are relatively lesser serious criminal offences that require a warrant from the court to be registered or investigated. These are generally bailable offences, and these offences would include crimes such as defamation, public nuisance, and minor assaults. I'm just giving very brief overviews because the time will not permit more than this. Now, another thing that will come to your mind is there any format for an FIR and what should one put in it? No, there is no format for an FIR, but yes, what one should put in it is an extremely important aspect. Please understand that an FIR is the beginning of the investigation, so you have to put in all the information that you can possibly think of. I would suggest that if an offence has been committed against you, you are obviously in an agitated frame of mind and there would be a lot of anger also, but you must sit in a composed manner, rethink the entire episode before you start writing it down in the FIR. Once a complaint is made, if all facts are not included, especially crucial facts or things that could be later deemed to be evidence, then one does not have a case. So in the event that sometimes we are likely to fail to remember each and everything because of a mental frame, so in such a case, I would suggest that please file an addendum complaint or an additional complaint informing the police that because you were not very calm and composed, you could not recollect everything. Now, this is something in which once the police gets the complaint, the police is bound to look into it and make an investigation. However, there are many times that the police refuses to do so. Then in such a case, what is it that one has to do? In the case that the particular police station where you have lodged an FIR, the police is not really investigating into it, you have the option of approaching the higher authority, which in most cases is the superintendent of police, informing him that you had lodged a complaint and the police did not take any action, or or register an FIR. In such a case, the SP will look into the matter, possibly assign another officer, and if it's of great importance, he or she may look into it themselves. Now, another important thing is, what is a warrant? And what is an arrest warrant? An arrest warrant is a legal document issued by a judge or a magistrate that authorizes the law enforcement agency to arrest a specific person and bring them before a court to face the charges. Now, I think we should understand very briefly what is the process of investigation. The first I would say is the police has to identify the suspect and gather as much evidence as they can in order to complete the investigation. The police at times can arrest the suspect if they feel that there is enough reason to do so. Generally, a person who has been arrested will be released on bail if it's a non-cognizable offence. Then they can be released by a bail even at the police station. The next thought that is likely to cross your mind, dear viewers, is what happens after the registration of an FIR. After an FIR is registered, the officer in charge then proceeds with the investigation of the offence. The process of investigation would include, but is not limited to, collecting evidence, questioning witnesses, inspecting the crime scene, forensic testing, recording of statements, and so on. If the criminals are found, the police will also make arrests. Once the investigation has been completed, then the police will record all their findings in a challan or a charge sheet as it is known. If it is deemed that there is enough proof in the charge sheet, the case will then go to the court. Upon filing of the charge sheet, the court summons the accused persons and then starts the criminal trial. Now I think I should deal with something that is a burning topic for many people. What should I do if an FIR is filed against me? The first thing I would say is, don't panic. It could be a false case. So first and foremost, get a copy of the FIR, read it for yourself, and thereafter go and select the right lawyer who can guide you as to what has to be done. Understand from him or her what your rights are and what is the gravity of the offences that you have been accused of. After which I would suggest that you collect all the evidence that you can think of to prove your innocence, whether it is oral or it's documentary or it is witnesses, etc. Once you have everything ready, you should reply to the allegations. This legal response, however, must be prepared by a lawyer, because invariably you would not be able to reply to all the points correctly. Of course, there will be a requirement for a bail if it's a cognizable offence. So in such a case, you will have to approach the concerned court, and the court will grant you a bail. A bail application could be either for a regular bail or an interim bail or even an anticipatory bail. Anticipatory bails are, however, not so easy to procure. One word of caution that I would like to give you, dear viewers, is that if you have been named in an FIR as an accused, yes, definitely there's a panic. Definitely you are going to be worried about it, but participate in the investigations. First, you ensure that you get a bail if it's a bailable offence, or a bail from a court if that is required. Once that is done, there should not be any doubt about joining the investigations. Joining the investigations would be of paramount consideration subsequently when the matter comes up in court. Now, having said that, I would now like to go to one of the most important cases pertaining to an FIR. This is the case which is known as Lalita Kumari versus Government of Uttar Pradesh, that was decided by a constitutional bench of the Supreme Court of India on 12th November 2013, and leads the path for how an FIR must be lodged, when it should be lodged, what are the steps that have to be taken, etc. In this particular judgment, the points that were there for the consideration of the court is whether registration of an FIR is mandatory when information relating to the commission of a cognizable offence is received by the police. The court answered in the affirmative and said yes, the police must register an FIR in the case of a cognizable offence. Now, what are the final directions that the court gave? The final directions, of course, one was that registration of FIR is mandatory when the information discloses a cognizable offence. Secondly, the court encouraged that there should be a preliminary inquiry conducted by the police in certain cases such as matrimonial offences, commercial disputes, etc. The court also held that a preliminary inquiry should be done in a time-bound manner, which is a period not exceeding 7 days. Reasons for closing the complaint must also be provided to the informant in case the police feels that no case is made out. All information and decisions must be entered in the general diary that is maintained by the police. The link of this case law is given on the screen, and if you have any further queries, you may go and read the same because it's a lengthy judgment. Dear viewers, we have started the Indian Lawyer Legal Tips as a social cause. We therefore request you to please try and circulate the episodes that you find useful to as many people as you can. I would also request you that if you have liked this episode, please give us a like, please forward it to as many people as you can, and of course, please subscribe to our channel. With this, I would like to say thank you and have a happy day.